Welcome to Jester Politics video, the Supreme Court, Guardians of the Constitution, or a ruling priest caste. In 1803, 4 Supreme Court justices decided Marbury v. Madison, in which the Supreme Court claimed for itself power to be final interpreters of what the Constitution says and means. Since nowhere in the Constitution does the Constitution actually bestow this power on the Supreme Court, Chief Justice Marshall engaged in some rather tortured logic to argue that Articles 3 and 6 did imply, at least, that the court had that power. From the moment this decision was made public, it's been roundly criticized by many of the foremost legal scholars in the nation, including Thomas Jefferson himself. To be fair, it has its supporters, many of whom are also quite accomplished legal scholars in and of themselves. But when pressed, they fall back on 2 arguments. The first is, of course, the tortured reasoning of Justice Marshall, and second is a pragmatic argument that only the Supreme Court can act as a check and balance on the other 2 branches of the federal government. But is that true? Marbury rests on 2 hidden assumptions. One is that justices and judges are objective people without bias. The second is that justices and judges will protect our liberties by objectively interpreting the Constitution. Unfortunately, both of these assumptions are demonstrably false. As an initial matter, I find it hard to understand how you can argue judges and justices who are appointed by politicians to a lifetime tenure as a judge or Supreme Court justice are objective and unbiased. Second, if Supreme Court justices are truly objective and unbiased, then why do we have so many 5-4 decisions along party lines? It would seem to me that if they were truly objective, we'd have more 6-3, 7-2, 8-1 decisions, not 5-4, and certainly not along party lines. Third, the fact that the political parties fight so hard to determine who gets to appoint justices to the Supreme Court proves that Supreme Court justices are in fact not objective. Remember Mitch McConnell and the Republicans blocking Garland's nomination in 2016, or the Kavanaugh confirmation hearings in 2018 in which the Democrats engaged in a prolonged, coordinated, and dishonest character assassination of Justice Kavanaugh. Honestly, if you believe that Supreme Court justices are actually objective, then it would really not matter who you appointed or when you appointed them. They would all interpret the Constitution as is written, but the simple fact is they don't. The second assumption, that the Supreme Court will protect our liberties against the overreach of the executive and the legislative branch, is also a myth. Just a couple quick examples. The only 2 times I'm aware of that Congress actually passed a law restricting our First Amendment free speech rights was first the Sedation Act of 1798 and second the Sedation Act of 1918. The 1798 Act made it a criminal offense to criticize the President or Congress, and as a result, over 25 people were jailed. Now, that act never got to the Supreme Court for review. However, Justice Caste of the Supreme Court gleefully enforced it while riding circuit. The Sedation Act of 1918 made it a criminal offense to criticize anything related to America's war effort in World War I. As a result, over 2,000 Americans went to jail for criticizing the government's action, one of which was Mr. Schneck, who got 10 years. His offense? Distributing leaflets critical of the draft. But the Supreme Court found all this comported with the Constitution. Strange way to uphold civil liberties. As bad as these 2 cases were, they pale in comparison to Korematsu v. United States, in which the Supreme Court found that President Roosevelt's executive order rounding up and sending Japanese Americans to what they called relocation camps, which were in fact prison camps, was entirely constitutional because they committed the non-crime of being of Japanese descent during World War II. To be fair, 18 Americans were charged with spying for Japan during World War II and 10 convicted. Of course, to be entirely fair, it has to be pointed out that all 18 of these Americans were, well, Caucasians. Simply put, the history of the Supreme Court from 1798 to present, when the Supreme Court refuses to weigh in on the Foreign Intelligence Surveillance Act, just shows that the Supreme Court really is not the protector of our liberties we like to think they are. As bad as all this is, it gets worse. I think the court's action in addressing constitutional issues fall into one of 3 categories. First, they set the scope of existing liberties that are obviously contained in the Constitution, such as free speech, freedom of religion, etc. Second, in some rare cases, they actually claim to find new constitutional rights that are not explicitly stated in the Constitution, such as the right to abortion in Roe v. Wade. And finally, they overturn previous cases that had addressed constitutional issues. I think setting the scope of liberties that are clearly defined in the Constitution is completely legitimate. However, once those limits are set, or once the scope is set, it becomes part of the Constitution. The second category, finding new rights and liberties that are not explicitly stated in the Constitution, is quite frankly a usurpation of the state and Congress's power to amend the Constitution in accordance with Article 5. Instead, the court just says, well, we found this new constitutional right, live with it. Finally, once the court addresses a constitutional issue and rules rules on it, that issue becomes a part of the Constitution. Therefore, the court is barred by Article 5 from overruling that decision because now that decision is a constitutional amendment and can only be changed in the two ways provided for in Article 5. Using Roe v. Wade as an example again, the court claimed to have found a hidden right to abortion in the Constitution. Therefore, the Constitution is effectively amended to include abortion as a constitutional right. Yet, the court in Dobbs overturned Roe v. Wade and held that there is no such right. You can put all the lipstick you want on that argument, but you can't get around the fact that both Roe and Dobbs amended the Constitution without complying with Article 5, and that is nothing more than the usurpation of congressional and state authority. We can continue to pretend that the Supreme Court is made up of 9 objective justices who use their power under Marbury to protect our liberties. Or we can face reality, which is that Marbury v. Madison gave the power to amend our Constitution without going through the constitutional process to 5 people dressed in black robes appointed for life by politicians who are accountable neither to the people, the states, nor Congress. Simply put, Marbury v. Madison elevated the Supreme Court from a co-equal branch of the government to, well, a body of ruling priests. What's the answer to ensure that we have a method of fairly and objectively interpreting the Constitution? I don't know. But I do know that the first step in arriving at an answer to the problem is to admit we have a problem and then have a national debate on how to fix it. Hope you enjoyed the video. Hope I didn't bum you out too much, and hope to see you back. Have a